a Greek philosopher known as Plotinus and Adam Smith. My favorite philosopher is called Karl Marx. And one of the most famous quotes that he made is this, that history repeats itself, first as tragedy, second as farce. Now, I go to my issue. Yesterday, Madam CJ, when I was listening to my learned colleague, Mr. George Oraro, Senior Counsel, I could not fail seeing the echoes of 2007 in what is happening today. Madam CJ, in 2007, the secretary to the commission, just like this year, was at the heart of what happened. The secretary was called Suleiman Chege. The secretary today is called Hussein Marjani. Same problem of numbers. The Kenya law reports would bear, and Mr. Isa Mansour is also here, that I represented Samuel Kivuitu and others when they were removed from office. Now, it turns out that, and listening to my learned colleagues, that just like in 2007, the person who knew why the results are like that was Suleiman Chege. Listening to the presentation yesterday, it also appears that the only person who really can tell us about these numbers is Hussein Marjani. Second similarity is that both Raila, Odinga, and William Ruto were at the heart of what happened in the year 2007. But that is not the more important point. The more important point is the differences. The differences were these. In 2007, and under the constitution that was existing that time, the election was announced on the 30th of December, 07. And the president sworn on that day assumed office. But the difference this year is this. After 15th courtesy of the new constitutions, on the 15th of August when the declaration was made, the person designated as the winner by Chebukati became president-elect. That's an important distinction. The second most important distinction is this, that the former constitution of Kenya did not have an equivalent of 138 of the constitution. There is that distinction today, which is what I was calling stage 3 of a presidential election. It was never there. The next issue was that in 2007, the presidential elections were held by the High Court under its original jurisdiction and special jurisdictions of elections. This one comes to the Supreme Court, and the basis upon which that is done is on the basis of Article 140 of the Constitution. There is no sitting president who will be appearing before you. There is only a president-elect. Now, my first petitioner, Julia Chege, asked me, because there was a subjective question that was posed in her view by Judge Smoky Nwanjala, that how come there was no protestations by these people when they were being given domestic chores? According to Julia Chege, who had to resign from her university job as a lecturer, there is something that needs to be understood, that for 99% of the human population, you want to follow the natural order of things. You don't disturb things. You let them things as they are. So that to Julia Chege, it is important that the court must understand that from your point of view, a lot of you, and she knows that history, have had a previous opportunity to stand up for something, an opportunity to say no. Not everybody has had that opportunity. And therefore, the 4 commissioners for ultimately, on the 15th, having the courage to have something to stand for. They are heroines and heroes of this country. We come now talking about heroes to what my professor of criminal law and procedure, Dr. Gethu Muigai, say. Dr. Mugai, looking straight to the face of this court, said two things. A, the problems in our elections is not IEBC, but the candidates. History does not support that conclusion. Second thing he said, B, Wafula Chebukati is a national hero. I don't have to say anything on that. Now, Madam CJ, there is the issue of the word independent, or in the designation of IEBC. The word independent, it is further elaborated by under Section 26 of the IEBC Act. It says IEBC is independent, but shall be subject to public participation and to engage stakeholders in the discharge of its mandate. Madam CJ and members of this court, I flatter myself quite often that I have a reasonable understanding of Kenya's electoral laws. However, Madam CJ, listening to my learned colleagues yesterday, I had a lot of reasons to doubt whether that is true, if what they said is actually the true representation of the law. And in several senses, under Article 81, the election should be simple, accountable, accurate. But until yesterday, my understanding was this, that reference to the Commission and Article 81, 86, 88, and 138 of the Constitution triggers the image of Chebukati and 6 others. I've never imagined Marjani and other returning officers when we talk about the Commission. B, based on sections 10 and 11 of the IEBC Act, my understanding has always been that the Secretary of IEBC is the chief executive, the head of the secretariat, the main employee of the commissioners, who appoints him. But now it appears to be that for purposes of a presidential election, and we heard it from his lawyers, he's actually the main man. Was this what the Constitution wanted it to be? Welcome to the Republic of Kusadikika. I must agree with my learned colleague, Mr. Muthomi Kiethiankulu, that it would appear that since we did our elections, we became some kind of a terrestrial Kusadikika, and several questions arise. When, why, and how? When did this happen? It first happened just before midnight or 9th of August, when we retired to bed. One figure we ought to have had was not known. How many of us voted? That is the when. How did it happen? It happened because on the 8th of August 2022, Wafula Chebukati published that Gazette notice that I had talked about. On the face of it, makes the chairman a dictator. No, that is not the issue. If you read it as an instruction manual, it was to give the job to Hussein Marjani. That is what happened. Why did it happen? It happened, and we explained in our affidavits, paragraphs 42 to 45, and what they say that effectively, on the 15th of August, when these elections were declared, from 7:30 to 6 p.m. on that day, the Commission, as the Commission, had lost effective control under Article 138 of the Constitution. I come, because I'm trying to rush myself, to the petition, number 7. This petition, Madam CJ, is actually a numbers petition. I didn't want to make a lot of fuss that I would have needed more time, but in case my mouth does not go fast enough, I urge you that you give me a little leeway to conclude what I need to say. The issue is this, Madam CJ. When you pose the question that you posed, how do you have evidence 700,000 people did not vote? You triggered some kind of public participation on my phone. I had many calls. Kibe, why did you just say it's 700? It's about 3 million. But of course I had to tell them, no, we just said 700 because we had some kind of evidence. So it's a big issue, Madam CJ, that you triggered a public participation. So many people don't vote on account of non-enforcement of Regulation 90 by IEBC. Now, for whatever the value is this. I can demonstrate very shortly, and we've done that in our petition and in our, in our affidavit, that when you have a petition based on non-compliance, how do you prove it? We have an affidavit of Julia Chege that basically has not been, has not been controverted. She says where she was voting. She was voting as an MP she was contesting the office of Kangema. And she said how she interacted with election officials. There were no affidavits sworn by the commissions to say those interactions she talked about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, Iebc needs